All right, so in this last section on sort of legal issues, I mentioned several times we've covered legal things throughout this semester, but one of the last things I want to talk about here is sort of expert testimony and basically genetics in the courtroom, okay, and some standards that apply. Now, these are broad standards that apply to lots of data, but certainly they apply to DNA data and the use of DNA data. So just first, a little bit of history, okay, because DNA data has not always been something that was used in court. I mean, I think for most of your lives, you think, oh, well, you know, we see these CSI and all these little programs on television and things, and the first thing they do is they get some DNA and they put it, and that makes it, you know, link the crime to potentially a criminal or to a victim or whatever. But as far as courts are concerned, certainly in this country, genetics data has not always been allowed. It's not always been utilized. The first, obviously, was some of the blood group data. And blood group data goes back around 1900. There was some groups in what was then Austria, which is Germany, some scientists that were realizing that their proteins, of course, had been discovered in the 1800s, and that there were certain combinations of those proteins in blood that could be extracted from blood and looked at, and things could be done. And in 1901, there was actually a murder case, a grisly murder case in Germany, where two young people had been killed and dismembered in a forest, and the suspect had blood on his clothing, and the scientists were able to extract some of that material using egg yolk and other things, actually identify that it matched up with the blood of some of the victims. Now, I didn't really understand ABL blood grouping at that time. It took another few years for that to work, but other scientists started to link in blood groups, and of course it became very important in World War I from the transfusions, because people were just literally plugging in a pipe into their buddy and then transfusing it into another, and it's causing deaths and things. But certainly by the 1920s, we understood ABL blood group, and certainly many other markers. In fact, a Nobel Prize in 1930 was awarded to a scientist for the work in ABL blood groups. Well, you can imagine that if we could identify blood groups and other markers, you know, Duffy groups. I mean, there's over 100 different antigen antibody responses that could be extracted now from blood, simple blood test. That this was interesting data, and we started to understand. Obviously, by this time, Mendelian genetics had come to the forefront. And in the early part of the century, we understood ABO. Understood that A was codominant with B, and both A and B were dominant over O. So we understood how you could be type O and type AB, and etc. But the first use of this, again, was at least in this country, the first successful use of in a court case was a case in the appellate court in New York in 1935. This was a case this was actually a civil case, dispute, divorce type case with infidelity. And there was use of blood. Now, this was the first time it was used. It was important because, for multiple reasons, this case, because about 1897 or so, there was always to the Supreme Court had been a decision that you couldn't require an individual to have a physical examination in a civil court case. Okay, and up to this point, taking blood had been considered part of an examination, a medical examination, and therefore couldn't be used. So this case involved using some blood material and tracing that blood to a case. And because of this decision by the appellate court, the the New York State Legislature took up the issue that same year and passed a statute that allowed courts to require blood tests. Okay, and it didn't say you had to do it, but it allowed you to do it. And then if the court did so ruled, then it was a required test. And these were ABO, other markers, and these were in civil cases, not criminal cases that had worked through in some cases. All right. Now, this same year, okay, in a New York City court, okay, so we're in the appellate court at one level, we're back in the New York City court, in Flippen versus Meinhout. This was, again, another paternity case, okay, And this one became very important because this was the first time in 1935 that with use of blood data now there, that the court ruled that there was no inference of paternity when there was only a possibility of paternity. And what does that mean? Well, that's an exclusionary ruling. Okay, it's basically saying, okay, the child has type AB blood. Okay, dad has type A blood. Okay, and there's some other, there's a possibility that he could be the dad, right, or the father, or the mother could have type A, and you're doing it from a, but this is paternity case. Obviously, it's usually where it's used. That just because dad had A and the child had AB, and it was possible that he was the father of this individual, that did not mean that he was the father. It wasn't put in court as an inclusionary. So for most of its time, well into the 1980s, blood groups were used only as exclusionary data. And we talk about that in general genetics sometimes, and you may have worked it in lab if you did that, when you did some little ABO blood group typing, trying to rule out individuals, right? So, which is science, right? Science basically says we don't accept hypothesis. We try to form hypotheses and reject those, and whatever we hope is left at the end is the truth, right? So it sort of fits with the way we approach science. But again, up until the 1980s, the use of genetics data, which was primarily blood group type data, and then later a little bit of some genotyping through proteins in the late 60s and 70s, but it was exclusionary. It was always exclusionary. You could say, okay, I can generally rule out this individual. This person has type O blood, the child has AB blood, or the victim, the blood that was left at the scene was type AB. I'm going to exclude. That's a piece of data that will exclude this individual. And I didn't prove they weren't, something, but it was exclusionary. Okay, so these are very important cases that went on for most of last century. So where did DNA data come in, right? We started to be able into the 1980s to sequencing had come along in the 1960s. By the 1980s, we were able to do it fairly effectively. We're starting to do RFLPs, restriction right stuff. If you don't remember that, you can go back to the lectures on methods, but RFLPs, DNA fingerprinting had come along. And we had very early times when we were starting to do a few microsatellites. We're starting to understand those. PCR had come along, but a Nobel Prize for awarding PCR. So we were able to rapidly take tiny subsamples of tissue or something off of a glass or something. If I could leave this, I'd leave my DNA in there, and we'd have something. So when did that come? Now again, it's part of everything. Well, first it was RSLPs and then microsatellites. And really the first functional case of this was an appellate court case in Florida, Andrews versus Florida. This was unfortunately a violent assault case, a rape case. And there was obviously samples left, the individuals. And this was through the appellate court held that DNA data could be used. Okay, this was 1988, so it wasn't that long ago. In 1990, the United States versus there's another case of this. This was the U.S. Court of Appeals. So this first case, Andrews versus Florida, was an appellate court, a state court. So it was the first time it was used in evidence, but it was in a state. The next court that said, okay, we can use it in federal cases. So FBI cases, I think, came in 1990, believe it or not, that late. In a Court of Appeals case where lower courts had ruled that DNA evidence could be used in this criminal investigation. And it went all the way to Supreme Court. Supreme Court said, there's no reason to hear this. It's straightforward, and that became the standard that's referenced back in any time with DNA data is brought into a case. Okay, as the reason that you could consider DNA. Now, DNA is not always considered in cases, and we're going to talk about that in a moment. But when it is considered, the precedence is there. Is this court ruling? Now, subsequently to this, as DNA evidence became more and more common, there was a transition. It originally had been exclusionary, just like ABO blood group. You couldn't use it as inclusionary. But once we figured out, particularly microsatellites, and even with RFLPs, but with microsatellites, you could predict, you could calculate the probability of that particular marker being in an individual. If you had multiple microsatellites, remember if we go back to our CODIS work and things, there's a number 7, 1, and 15, etc. If you had a suite of those, so say 7, 10 microsatellite markers, and you knew the probability of each one, you could do the combined probability of those, and that's what's actually done. There's lots of papers and manuscripts on how you do that, and how you do it for mixed DNA samples and all that. But basically, you get the joint probability. You say 1 in 2 billion, or 1 in 500,000, or 1 in whatever probability. So they would set it up. And in doing this, they made the data inclusionary. So now, as you know, are probably used to in your life for the last 30 years or 20 years, is that they go in and they say, oh, yeah, that's Billy, and Billy was there. Okay, he didn't necessarily do it, but his DNA was at the scene. This is a DNA from something else. So that's a major shift, and it came about in a series of cases in the mid 1990s, fighting for it. Now, how did it do that? That's the question here. What rules were in place to kind of say, well, why didn't you just accept it, right? Well, it turns out there were two big sets of rules, actually 3, but they intertwine. So we're just going to look at the 2 primarily. One, and it's still used today, the one that really impacted this was what was known as the Frye Standard. The Frye Standard came about in a court case in 1923. A new scientific method was being used. It was called the systolic blood pressure perception test. Basically, they would put a blood pressure cup on an individual. They would check their blood pressure. They would ask them a series of questions, and they would see whether or not the blood pressure went up or down as a response. Okay. Now, there was this was rejected by court as in a murder case, and it was rejected, and it set standards that are still applied today. Okay. What it said was, what the court ruled was that expert testimony must be based on scientific methods that are sufficiently established and accepted. Those are big criteria. It must be sufficiently established and accepted. This was not. This was one of the first times it had been used. There was no published literature on it. It was somebody who came up with the idea that this is how you do it, and this is what we're going to use. Okay, and the court said no. We need some evidence that this is functional, and this became the ruling system for here. It still is in place in many places. Okay, in fact, there are a number of states that currently use the Frye Standard. California, Illinois, New York still say that expert testimony, me giving expert testimony, must be based on scientific methods that are well established and accepted, and it's the burden of the expert or the person presenting the data, the attorneys, to prove that this condition is met. Okay, and it is important. Okay, now 50 years later, it took almost 50 years. Well, in fact, there's 50 years. This was 1975. There was a federal rules of evidence finally came into place. Okay. And under these federal rules of evidence, rule, particularly the one that you see very often cited, is Rule 702. And this relates to presenting evidence, scientific, whatever. Now, it's broadened. In other words, it says if scientific, technical, or other specialized knowledge will assist. Okay, now that part right there is very important. What's really important about Rule 702 in many cases is that the data or the information or the expert opinion must assist in helping those understand what's going on. Okay, must understand the evidence. So you can't just say, okay, here it is. All right, it must help the system understand it. So you must, and this is basically saying that a reasonable person, a jury or whatever, if someone's presenting evidence, then that evidence must help the jury or the defense or whoever to understand what's going on. Okay. A witness qualified an expert by knowledge, skill, experience, training, or education may testify here to the form of an opinion or otherwise. An opinion. Okay. As an expert, my opinion is, and you often hear that in court cases where the expert comes up and says, in my opinion, this painting is real, or this painting is a fake, or whatever. Now notice it says it doesn't define it to genetics data or anything else. This is about, and or even scientific data. It could be technical data. It could be like, no, this is I'm a technical expert on 18th century manuscripts or something. Okay, it works, right? But these rules had to apply. Now there was a lot of conflict, and there still is conflict between this rule because it's a bit broader. It's in fact much broader than things where it doesn't say anything about the opinion being based on methods that are sufficiently established and accepted. And that's why, even though this is a federal rule for evidence, some states don't actually use it. What overlays it and what states make a decision about accepting information as evidence is the Frye versus United States, okay, the Frye standard. Right. So that's why I said there are really two big cases. The Frye standard is the first, but there were three things involved. One of them is the federal rules of evidence is kind of this thing that's overlying all of this system. Okay. So the Frye standard was there until one that's now very commonly used and has different rules. Okay. We had the federal rules of evidence. But in 1993, there was a court case between Dalbert and Dow Pharmaceuticals. And this had to do with whether something product was tested, whether data, and this is a big deal because lots of companies, pharmaceuticals and other things will hire, will farm out testing of their products. We have this in agriculture and all sorts of things. I have friends that, they're supported by a research project by so-and-so company to test this product versus another one. And, they do their best to be objective and scientists, but, you're under pressure from the company that they want their product to be better, right? So how those systems work and things. This was the Dalbert standard was set by this decision in 1993. It was reconfirmed and further set by another one in 1999. Okay, so that's only 20 years ago. And this changes the system because now the judge becomes the gatekeeper. All right, the judge really is the one who's going to make a decision about whether or not the evidence meets a standard. And the standards that are brought forth out of the Dalbert standard are these. Okay, it really looks at the scientific method that's applied, right? Was that it uses, particularly in science knowledge, so DNA in our case, is one of the reasons that DNA took so long to become a system, become and allowed it to become inclusionary, is that there have been hypotheses tested and posed. That's how science works, right? There must be a known or potential rate of error determined. Right, so that's very important. Okay, what's the error rate? How many times does it make a mistake? How do I know it's made a mistake? What's an acceptable rate, etc. Okay, have they been peer reviewed? All right, that had nothing to do back. If we go back to the Frye standard, it doesn't say anything about peer reviewed. It says it's sufficiently established and accepted. Okay, but not the words peer reviewed. Okay, here, so it must be published. In other words, you can't just go out and write up a report from a chemical company, or I couldn't just write up a report from my lab and say, oh, by the way, we've got this technique and it really does a great job of this. No, it has to go out to peers and it has to be peer reviewed and published. So it has to be scientific information. Are there standards controlling? Okay, in other words, are there controls that have to be applied? Are there certain levels of those controls? And that relates again to this known rate of error. How do I test that? How do I do that? If I hand it to someone else, will the technique work? And will it have standards that I can apply? Okay, and is it generally accepted within the relevant community? Or is it, do people who are geneticists accept this technique as being one that will work? Will PCR produce a product that can be used, generally accepted as part of a method to produce outcomes? Okay. Now, this actually is because of this part, because the wording, not these parts, but because this part where the judge becomes the gatekeeper, it's actually a bit more lax. It doesn't sound like you say, well, no, I need rates of error, I need all this sort of things to come in there. But in reality, because the judge becomes the gatekeeper, the standard for the Dalbert standard is actually somewhat less stringent than the Fry standard, you know, because the judge makes the ultimate decision. It's not, you know, it's really there. It sounds a little weird, but if you read anything about these two standards and the systems between them, you'll find out that this component of it up here, the judge is the gatekeeper, really is one of the driving elements here. Okay, well, these are too important, and the reason I'm bringing them up is to kind of, you know, let you know that there are rules, that it all hadn't happened 150 years ago. I know everybody thinks about history, you know, before, like slightly before we were born is, okay, there was the Magna Carta and then there was the Constitution, you know, and no, there's 600 years difference there. You know, it didn't, this stuff has been through the system. The other part is that, you know, I say it over and over again, is who we vote for. Okay, and I don't care who you vote for, none of my business, but making educated decisions about those things makes a big effect, right? How data is used, how information is used, who's allowed to present it, all that comes from the court systems. Court systems are generally politically related systems. So, you know, whether in state or whether in federal, and again, it varies by state or whatever. The last one of these I'll talk about is just fingerprint evidence, just to show you how this can work. Should public opinion have anything to do with admission in court? So we all know about fingerprints. You got arches and loops and things. We all know that you know, they develop in the right side and the left side. They can be different because of environment, and you know, we can have epigenetic effects. We can have all sorts of things going on. We can have mutations so that we have, you know, whorls on one side and arches on the other side. We can have all sorts of things. But fingerprints, you know, and it's one of the classic things that things. So the question came about was, does fingerprinting, you know, does it meet all these standards? And a judge said, you know, the first use was back in 1911, fingerprints, and since then they've been a staple of court cases, of you know, police and investigative research and investigations about how to use it. Okay. But in 2002, there was a case where a judge actually said, you know what, if you really look at this, fingerprints don't meet the Delbert standard. Okay. Why not? Well, there's no known error rate, right? There's no publications on, okay, how many times do we put this down and we come up and we say it's a loop, but in reality, it's a double loop. Okay. What's the error rate there? Well, I mean, there's not many characteristics here. You know, whirl or a mixed, you know, what if you got mixed? What's the rates of that? Of course, the methods have been out there and peer reviewed. There've been discussions. Is there controls? You know, in other words, it's a scientific control. When you go get your fingerprint done, they take you and they hold your hand down and they go, you know, and in the old days, they would put you in an ink pad and they do it like this, right? Or they go through a fingerprint. If they're taking a fingerprint off a piece of glass or something, they go up and they dab some charcoal on it. They lift it off with some tape. Is there a standard for that? You know, do you put a fingerprint on there and see how well it lifts off to see, you know, here's the standard. I've got a standard fingerprint. If I go and I take somebody's finger and I do a print, do I do a standard print somehow? Is there, you know, is there controlling? Do I do two of those? Okay, do I just take one fingerprint and that's it? Well, yes, how it's done for the most part. You know, there was no controls. All right, we didn't do controls about how the evidence was collected in reality. We didn't do any controls about how fingerprints were taken from individuals. You know, they weren't duplicate or triplicates and done and then tested, and the probability of error come up. So essentially, it didn't meet the standard. Okay, and that's what the judge said. Said, in reality, we need to do more work here to make this meet the standard. Even though we've been using it for over 100 years, we need to do this. Then the public outcry, as you can imagine, from you know, from attorneys, from the legal system, from just outsiders reading this, from police and other investigative units, FBI, are just like, it's been working for 100 years. It's a family tool. Why do we need a standard for this? And he actually later reversed his decision because of the public opposition to this, because, you know, court rulings are set precedent, right? So his court rulings set a precedent. And in fact, it did reverse. And it's an interesting case of reversal of this. So we do sometimes have these techniques that don't meet the standards that are used. And so these both the Fry and the Dilbert standards are very, are used flexibly. Sometimes they're applied, sometimes they're not applied, sometimes they're applied piecemeal. It's kind of it's an interesting problem. All right, well, that's really all I wanted to say about those. I think that's quite a bit. You will, you may or may not face them. People who deal in genetics data, whether it's human or whether it's animal or plant, very often get called on as experts, and you get involved in these things. So it's kind of important to know that there is this background to it for it. Years ago, back in when before we had national labs and state labs that had their own systems and controls, I would get called back, particularly with RFLPs, when I first, started doing this, and I'd get calls from attorneys, I've got these data and I don't understand them and I could go look at them. And I fortunately never had to testify in a court case that involved humans. I testified several times, federal, state cases that involved endangered species and genetics of those systems, but not federal. Nowadays there are established codes, there are labs, there's experts. People go to an expert and say, and they've got a proven track record, and the courts will accept them as the expert in that area. Fortunately, people like me don't have to end up doing this anymore, nor getting emails with a paternity printout and saying, I got this, and am I the dad or is he the father? Ooh, I don't want to okay, give you an opinion on that. I've had that happen a number of times in the past too. All right, so that's the end of that, and that should end now what we're going to discuss about legal, other than some readings and things that we've posted in this chapter. So we'll move on to the next part of the module.